Good day and welcome to today's LexCast. It is the 11th of January, 2006. Well, ladies and gentlemen, I know that I've asserted a couple times in the past that the courts appellate in Virginia are actually liberal courts. And my proof in this has been that they don't use plain language interpretations of statutes, or at least it's not been my experience that they use plain language interpretation of statutes, favoring instead interpretations which are based on legislative intent, which is a fairly liberal way to interpret a statute, because as we all know, when you delve into legislative intent, you don't really get, well, let me not say it that way. There are a fair number of people out there who believe that when you say legislative intent, you are substituting your will for the actual language of the statute. And that the legislature, even with whatever incomplete records were passed forward with a statute, the legislature, you're not capable of knowing the purpose of every person who passed that statute. So the 5 or 10 people who put together that legislative intent statement might be the senior members of a certain party or appointed by senior members of a certain party, whereas the 90% of the people who passed the statute had an entirely different meaning, an entirely different reason for passing the statute. So legislative intent is not looked upon, or a number of people do not look upon legislative intent as a means of finding the true intent of the statute. The true intent of the statute being found by what's actually written into the statute, and the thought which follows then is that when you find legislative intent and you change the meaning of the statute from the plain language, you are thus legislating from the bench. Okay, now that's the theory behind it all. What we do find in Virginia, at least, and obviously I read mostly criminal law cases. This may not be true in civil cases, but in criminal law cases we do get a whole lot of legislative intent, quite often without any real follow-up as to we got the legislative intent from here or there. It often seems to be that the legislative intent is to make sure, your client counselor goes to jail. But that's a little bit cynical of me. Well, anyway, I want to read to you some boilerplate language, and this is the kind of language you see in cases in which it's very difficult to get around the plain language of the statute. Where the plain language of the statute, as passed by the legislature and signed into law by the governor, is pretty clearly running the opposite direction. In these kind of cases, we get this kind of boilerplate. As always in such cases, we are guided by well-established principles of statutory construction. The proper course in all these cases is to search out and follow the true intent of the legislature, and to adopt that sense of the words which harmonizes best with the context, and promotes in the fullest manner the apparent policy and objectives of the legislature. And by the way, that runs squarely in the face of the rule of lenity, one of the oldest and most hallowed rules of statutory interpretation. But I digress. They go on, and of course there's quotes from a number of cases, Jones against Ray, quoting United States against Wynn. See also Last against Virginia State Board of Meds, explaining that the statute's construction's main purpose in explaining that the statutory construction's main purpose is determining legislative intent, which, absent constitutional infirmity, must always prevail. Quoting Board of Supervisors against King Land Corp. New paragraph. Thus, while legislative intent must be gathered from the words used, unreasonable or absurd results must not be reached by too strict adherence to literal interpretation. Buzzard against Commonwealth. In addition, Statutes in pari materiae must be considered together in construing their various material provisions. Id. This requires that the literal meaning of separate provisions, if in apparent conflict, must yield to a reasonable and fair interpretation to be gathered from the context, the subject matter, and the reason and spirit of the law. Similarly, a provision of a section of a statute ought not to receive a mere literal interpretation when it would contravene the intention of the legislature, apparent from the other sections and provisions thereof. Found against Department of Game and Inland Fisheries, quoting Tab against Commonwealth. We do not isolate particular words or phrases, but examine a statute in its entirety. Altice against Roanoke County Department of Social Services. In doing so, we have a duty to interpret the several parts of the statute as a consistent and harmonious whole as to effectuate the legislative goal. Virginia Electric and Power against Board of County Supervisors. Furthermore, where applicable, as here, we must keep in mind the evil sought to be corrected by the legislature. Now, this is not to pass judgment on a particular case. I pull this out. This is a case that was published today, Colbert against the Commonwealth. And I'll tell you, this is far too complex a case for me to say whether the final interpretation is correct or not. I would have had to spend hours looking at statutes and laws and stuff. But it doth seem in this case that the Court of Appeals objects too much. Let me put this. Here's what's going on in the case. A guy is caught trying to solicit sex from a minor over the internet. The person who he's soliciting from is a cop. The cop traps him in. He gets convicted. Okay. It's well settled under our law that they can do that. Well, when he gets sentenced, he gets his 4 years and some other things. When he's sentenced, part of the sentence is that he's got to register as a sex offender. Well, his attorney objects and says, no, the statute says if a minor is involved in such and such offense, if a minor is involved and he commits such and such offense, then he has to register as a sex offender. The Court of Appeals rejects this, says that prefatory language, that a minor is involved, doesn't really mean what it says, or just should be ignored, basically. It does a blow-by-blow interpretation of the various statutes, because it's one of the statutes where it goes, and if it violates any of these statutes, and just lists a whole bunch of them. It does a blow-by-blow of the statutes that are in there, and I didn't bother, I don't have the time right now to go through and read and look at each one of these statutes and do an in-depth interpretation, which is why I can't say that the Court of Appeals is wrong here, like it's my place to say that. But I can't point to this and say it's wrong. I can point to it and say, the language as they laid it out makes it seem like the plain language is against this opinion. And then, as far as they go, they seem like they're going an awful long way to get around it. Now, one thing I will say here that's not something I commonly see in these cases. A lot of times in these cases they talk about the legislative intent, but they don't ever provide any kind of proof of what the legislative intent was. In this case, and I got to give the judge props here, the judge did give quotes from the legislative intent, some legislative intent that was when the bill was passed, and uses that to further her case. Like I say, a lot of times you don't see that. Even though I obviously disagree with these kind of interpretations, I do have to give the judge credit for going and actually finding legislative intent instead of just assuming it. Anyway, ladies and gentlemen, that's my one little rant for the day. Let's go on and talk about some cases which have popped up. First case today is from the AP, sfgate.com, which is San Francisco. The legislature in San Francisco, one of the committees, has decided that it's going to forward a bill and recommend that the death penalty, that there be a death penalty moratorium, and in all probability, we know where that's headed. That's headed towards getting rid of the death penalty. This on the heels of New Jersey's legislature yesterday or a couple days ago being the first legislature in the United States to declare a moratorium against death. To declare a moratorium against the death penalty. Now there have been other moratoriums prior to that. I think there were a couple of them, including, we all know, the Illinois. I think it was Illinois. But those were put in place by governors, not the legislatures. And then we look on and we see from the Concord Monitor that the legislature there is considering two different bills about the death penalty. One of which is to get rid of it, and the other of which is to expand it to almost every murder case there is. And the governor in New Hampshire, Governor John Lynch, has said that if the bill to get rid of the death penalty comes before his desk, that he's going to veto it. And they quote in here also that one of the legislators talks about how if it's passed the other way, the other bill is passed, and all these things, all these murders become death penalty eligible, how it's just going to become incredibly expensive. And I can see that because we all know about the appellate processes and the cost of having two attorneys rather than one. For instance, in Virginia, if you're merely charged with murder and you get your court-appointed attorney, I think now your court-appointed attorney's fees top out at something around $1,200, somewhere like that. It used to be $1,096 until July. Whereas if you are accused of a capital murder, you get two attorneys. There's basically no cap on the fees. Of course, the judge has to approve things. There's really no cap on the fees, and it can just get incredibly expensive for that trial. And I'm sure it does get incredibly expensive for those trials. I don't think that, probably New Hampshire doesn't have the same level of pay for court-appointed attorneys that Virginia does. It's probably a little bit more expensive for a plain murder there than it is here. But I'm sure there's a large discrepancy between the costs of the two types of prosecutions. And now, the next story, and this seems to be death penalty day. This is just the stories that rolled off when I was checking around. Comes from the seniorjournal.com. And this is about questions which are now being raised about whether the elderly should be executed. And we've already excluded the mentally infirm. Well, not the mentally infirm. Let's not say that, because there's a lot of people that are mentally infirm in one way or another. We've excluded the mentally retarded from being executed. We've excluded those under 18 from being executed because that's the arbitrary age at which we assume maturity. And now the question is, should we exclude the elderly from execution? And here it's talking about, a gentleman by the name of Allen, who is going to be 76 years old, Clarence Ray Allen, who's going to be 76 years old the day before he's supposed to be killed by the state of California. Now, Mr. Allen is a wheelchair-bound, nearly deaf, blind individual who's going to be forced to walk the last 12 feet or so, or probably be carried by the deputies the last 12 feet or so, to his own execution because, well, the execution chamber is not wheelchair accessible. Our next story for today comes from monstersandcritics.com, where we find out that everybody's favorite mayor, Marion Barry, has been found in violation of his is in violation of his probation because he has cocaine in his system. He hasn't had his bond revoked or anything like that. He's on bond. He faces a possibility of 18 months in jail, 18 whole months. This is the difference between being convicted in Virginia and being convicted in D.C., folks. He wouldn't be facing only 18 months if he was here in the Commonwealth. And his attorney is trying to get him treatment rather than being locked up, putting forth the defense that this was just a minor violation of his probation. And our final story of the day, ladies and gentlemen, comes from the Rutland Herald. And we have an interesting story here where the police go to pull up and stop a vehicle that's on the road, and just as they go to stop it, the driver and the passenger switch places. Apparently under the theory that, well, the driver is drunk, so we'll put the passenger in the driver's seat. The failure of this theory, however, ladies and gentlemen, is that, guess what? The passenger was drunk too. And the money quote here is, folks, comes from City Police Lieutenant Kevin Gino. It was a twofer. It's rare, but it does happen when they switch seats. And ladies and gentlemen, that concludes today's LexCast. I hope you found something useful and something enjoyable, and maybe even learned a thing or two. Anyway, I think tomorrow what I'm going to broadcast about are all the drug cases which I've seen, which have been interesting this week. There's been a couple that have had some interesting spins to them, and so I think that's what I'm going to put up tomorrow. And until then, y'all have a good day now.